At just after 5:30 in the morning on the 8th of December 2022, in open water between Guernsey and Jersey, a large roll-on and off ferry, the Commodore Goodwill, collided with the Jersey fishing boat, Lacombe 2. The fishing boat was tiny compared to the Commodore Goodwill, which had a gross weight of 11,200 tonnes, and Lacombe 2 was destroyed in the collision and sank instantly. Tragically, the three occupants of the fishing boat, the skipper, Michael Michieli, and the two crew, Larry Simyunn and Jervis Baligat, were all drowned. Michael Michieli was aged 62 at the time of his death. He was well known locally for his skills as a fisherman. Larry Simyunn was 33 and Jervis Baligat 31. Both of those came from the Philippines. All three had a good part of their lives ahead of them and have left families grieving their loss. At the time of the collision, Mr. Carr, a second officer, was at the helm of the Commodore Goodwill, and he had the responsibility for safely navigating the ferry between Guernsey and Jersey. Mr. Carr was not experienced compared with some other senior officers on the ferry, but had been carrying out the duties of second officer, which included navigating the boat, for 2 years by the time of the collision. He had all the necessary qualifications and training to safely navigate the boat. He was assessed by others as being good at the job. At the time of the collision, it was dark, but otherwise visibility was good, and both boats were fitted with radar. It was said to be exceptionally good weather for December, and the sea was calm. Both boats were in good condition and had all the necessary equipment to enable them to avoid a collision. The Commodore Goodwill, unsurprisingly, had a good deal more radar and other navigational aids than Lacombe 2. So why did this collision happen? The evidence was that the Commodore Goodwill was late leaving Guernsey. That was not the fault of Mr. Carr, but when he took over the helm from the captain after leaving Guernsey, he was told to get to Jersey as soon as possible. He was not being told by the captain to risk the safety of the ship, and he knew that he shouldn't. The court is satisfied that he was in a hurry, and that affected some of his actions. Everyone who works on a ship or a boat knows how serious a collision can be, so there are regulations to try and make sure that they are avoided. In addition to rules which affect all seafarers, there was a rule introduced by the captain of the Commodore Goodwill and others that, where possible, the ferry should not come within 1 nautical mile of any other vessel. This was not always possible when close to a harbour or when in congested sea lanes, but it was possible on this occasion, as Lacombe was the only vehicle close by. Mr. Carr should have acted in compliance with that rule. Mr. Carr first saw the lights of Lacombe 2 when it was a number of nautical miles away, and at which time they were sailing towards one another. At the time of his first sighting, Mr. Carr had ample opportunity to alter course so as to avoid Lacombe 2 by a nautical mile. That is what he should have done, and he didn't. He could have done that before any risk of collision had arisen. As Mr. Carr accepted in his evidence at trial, had he done that, this tragedy would have been avoided. After seeing Lacombe 2, Mr. Carr continued to sail towards it at a top speed of 18 knots, which had been set by the captain so as to arrive at Jersey as quickly as possible. Once Mr. Carr took over the helm, it was up to him to travel at a safe speed. He did not reduce speed before the collision. What Mr. Carr did when still over 4 nautical miles away from Lake Cum was to alter course slightly. In evidence during the trial, Mr. Carr said that he did this because Commodore Goodwill had drifted off course and he was correcting this. That is not what he said in his account in the various interviews that he had soon after the collision. In the interviews, he said that he had made the course alteration to open up a gap between his boat and Lake Cum so that they would pass safely port to port. The prosecution say that the accurate answer was what Mr. Carr said in his interview, not what he said in court. The court accepts the prosecution's argument and is sure that what Mr. Carr said in the interviews was what he was really trying to achieve by this manoeuvre. He was hoping that this change of direction would be sufficient for the vessels to pass side by side without colliding. While the court accepts that Mr. Carr was very affected by the collision and its consequences at the time of the interview, the court cannot understand, having heard the evidence and his explanation, how he would have come to have said what he did if it hadn't been true. So, at an early stage in our judgment, Mr. Carr should have taken avoiding action to ensure that he passed nowhere near to Lake Cum. He didn't do that, and the vessels continued on their course. 10 minutes before the collision warning light came up on Mr. Carr's radar. That was a warning that if both boats continued on their course, there was a risk of collision. Once the risk of collision had been identified, the international rules of the sea, known as col regs, applied to both boats and determined which boat had to give way to the other. The prosecution argued at trial that Lake Cum was showing fishing lights, which meant in practice that the Commodore Goodwill was the give-way vessel and should have moved out of the way of Lake Cum. And at one stage in the interview, the defendant did say that the Commodore Goodwill was the give-way vessel. The defence argued that there was no direct evidence that Lake Cum was showing fishing lights, and what evidence there was suggests that it wasn't. I do not consider that the jury could have been sure on the evidence that Lake Cum was showing fishing lights because of the verdicts they reached. And accordingly, the court will sentence on the basis that after the risk of collision had been identified, the Commodore Goodwill had right of way, and the obligation was on it as a stand-on vessel to maintain its course and speed until it became clear that in order to avoid a collision, it should take avoiding action. Lake Cum did not alter course, even when a collision was becoming more and more likely. Why that was, we will never know. The skipper, Michael Michieli, was in the engine compartment carrying out some work. In those circumstances, it would be expected that one or other or both of the crew would be on the deck keeping a lookout. They clearly weren't, but why, we don't know. And because we do not know, the court will not speculate. But whatever fault there may have been on the part of the Lake Cum crew, when it became apparent that the Lake Cum was not altering course, it was for Mr. Carr to avoid the collision. He did alter course, but it was too little, too late. He sounded his whistle, but not until the Commodore Goodwill was almost on top of Lake Cum. He should have altered course earlier, and had he put the boat on manual steering rather than remaining on autopilot, he would have achieved a much more rapid turn and may well have avoided the collision. He should have sounded the whistle at a time which gave Lake Cum an opportunity to respond to it. So why didn't Mr. Carr take avoiding action? It was his job to avoid a collision as navigator. He did not deliberately crash into Lake Coombe 2, but he became distracted from his main task, which was to avoid a collision, by doing other jobs which he had to do before the ferry reached Jersey. In that crucial 10 minutes between the collision warning being shown and the collision happening, he made a number of phone calls. He rang and spoke to the Jersey Coast Guard. He rang the engine room to give them advance notice of arrival in Jersey. They rang him back and he answered the call. He spoke to the captain to give him warning of the approach to Jersey so that he could take over the helm. All of those things he should not have done at the time. He could have done them later. Because he did those other tasks, he meant he did not concentrate on his main responsibility, which at that time was to avoid colliding with Lake Coombe 2. Had he been solely concentrating on avoiding the collision, it could have been avoided by making an earlier turn, reducing speed, going over to manual steering so that a sharper turn would have been possible. As a result of what he has done, Mr. Carr was convicted of one offence of conduct endangering ships by the jury. The maximum for that offence, and it is important that I emphasise this, that the court can impose is 2 years imprisonment. The court needs to decide the appropriate sentence within the sentencing powers given to it by the legislature. The sentence we pass needs to take into account the harm that Lewis Carr has caused. 3 men have lost their lives. Their families are feeling and will continue to feel the pain of their loss, which has been devastating. That said, the sentence we pass is not intended to, nor could it, reflect that loss. No sentence can undo the tragic events that have happened, nor can any sentence we can impose make it easier for the families to come to terms with their loss. But the fact that 3 people have lost their lives is something that should be taken into account in the sentence, even though it needs to be borne in mind at all times that the maximum sentence for this offence in Jersey, which is the same as England and Wales, is 2 years. We also need to consider the culpability of Mr. Carr for what happened. He didn't deliberately cause the collision. He was feeling under pressure as the ferry was running late. He made the wrong decision in not keeping 1 nautical mile away from Lake Coombe 2. He failed to make appropriate use of the considerable amount of radar and collision avoidance equipment that he had. He failed to properly make use of the lookout who was available to assist him. But perhaps most importantly, he failed to devote all his attention to avoiding a collision. He divided his attention so that he reacted too late to what was happening in front of him. Personally, there is a great deal which can be said in Mr. Carr's favour. He has no criminal convictions recorded against him, and he has lived a hard-working and constructive life. We have read a large number of testimonials from his family, from his friends at home and from school. We've heard from people who have known him for a long time and can talk with authority of the sort of person he is. People with whom he has worked speak highly of his qualities as a man and as a worker. They speak of him as someone who works hard and is good at his job. It is clear that Mr. Carr's behaviour on this occasion was out of character. Mr. Carr has written to the court expressing his remorse for what he has done. He has satisfied the probation officer, who has prepared a very helpful and entirely realistic report for the court, that he feels genuine remorse for the 3 deaths and the effect that those deaths have had on their families. We have also read a report from a clinical psychologist reporting on the effect that the collision has had on the defendant. She reports that the defendant is suffering some of the symptoms of post-traumatic stress disorder. She is an experienced psychologist, and she regards the symptoms as genuine and has recommended some treatment to assist him. We have read reports of other cases of a similar nature. They don't, and they don't seek to, set down any principles for sentences to consider. It is for the jurats to decide on the appropriate sentence on the facts of this particular case, balancing all the various factors that I have set out. The court will apply the following principles. First, the court takes the view that where there are multiple deaths, sentences close to the maximum sentence are justified. There is personal mitigation, and that should be taken into account to some extent. In addition, there has been delay before this matter has come to trial, which has had an effect not only on the families, but also on the defendant, and that should be taken account of. These events will have consequences for him in his future life and his employment. Would you stand up, please, Mr. Carr? Taking all those matters into account, the court has decided that the appropriate sentence in this case is one of 20 months imprisonment. Thank you.